welcome to this first lecture for the Honours Victimology module at University of the West of Scotland. I'm very glad that you're all with us for this Honours year in some unusual circumstances. So this first lecture will take the form of two separate videos that will be uploaded. This one just now, where we'll be talking about some of the history of victimology and victimisation, putting into context some of the issues we'll be talking about as we go through the term. The second video, which you should watch after this one, will then go in depth a little bit more with some of the theoretical developments as it comes to victimology. So we'll be starting off in this video, as I say, looking back to the history of victimisation within the modern criminal justice system as we have it today. And we're going to start off by looking at the victim's role in the early modern criminal justice system. Because when you think about victims just now, you're likely thinking about those that are coming to court to give testimony, something that's happened to them. They've maybe been assaulted or raped, or there's been some theft or something like that. And the victim is the person that then goes to court and has to make statements. After having made statements to the police, they then have to go and give testimony to the courtroom. But effectively, victimisation you may view as being somewhat of a passive role, if you like, within the justice system, in that they're effectively, albeit a chief witness, simply a witness in the case when it comes to the criminal justice process itself. And it's been an interesting journey that has taken place to get us to the point we're currently at, which has taken some peaks and troughs in what the role of the victim is in the criminal justice system. So if we were to look to the early developments of a modern criminal justice system, as you might understand it to be today, Hay and Schneider in 1989, they said that not only assaults, but virtually all thefts and even some murders were left to the general public. In other words, the state itself didn't necessarily take an active role. If we were to go back some 200 years or so, for example, the state may not have taken an active interest or an active role in acts of criminality that took place amongst general society. So Hay and Schneider said not only assaults, but virtually all thefts and even some murders were left to the general public. That meant that responsibility for the initial expense and the entire conduct of the prosecution was thrown or left to the victim and the victim's family. And as late as the mid-19th century, there was no public official that was fully responsible or solely responsible for ensuring that even the most serious offences were prosecuted. So that was Hay and Schneider in 1989 that said that. So effectively what they were then saying is that there was almost a double whammy, that an individual would be victimised, let's say through a serious assault, and the state at that point, going back some 200 or more years ago, the sorts of cases that they were taking to a court would be often those whereby it was a member of society's elite, let's say, that had been either assaulted or the victim of a theft or a family member had been murdered or something like that. And it would be then that the state would become involved. Or if there was some sort of act against the state, then the state would become involved. However, if there was an ordinary act of victimisation, as you may call it, between ordinary citizens, then the state may not necessarily have taken an active interest in the case. It was viewed almost in the same way that civil cases happen today, where it's one private person taking an action against another private person. And that was the case even with a large bulk of the criminal law at that stage. So if somebody was a victim of, say, a theft, then it might be up to them to take out a private prosecution against the offender if they were able to track down that offender. And the costs, the full costs for that criminal justice process, including renting out the court spaces, including paying expenses for any witnesses, etc., if they were going to come, because it was a voluntary basis then all of those costs had to be borne by the victim or the victim's family. So as we say, there was almost this double dunt, if you like. The initial victimisation suffered by the victim, and then the costs associated with the criminal justice process. So the victim, going back to this early stage of criminal justice, was actually very active, almost central within the criminal justice system, because without the victim, taking matters forward themselves, then there would often be no criminal justice process to speak of. So the victim's role was very central. And I mentioned wealthy people and people of high standing. So often you'll find that a lot of those early cases were being taken forward to the court system by those that had the wealth, had the finances, had the resources to actually take people to court for criminal offences. So what we found was that wealthy people of high standing would form organisations in their locality that would be almost similar or comparable to a neighbourhood watch organisation today. So these wealthy people would form organisations known as associations for the prosecution of felons. So this is where you might have 20 or 30 high-standing individuals in society that would club together, and they would each pay subscriptions or a little bit of money into the pot, so that if any one of them was a victim of a criminal offence, then money could be taken from that pot to seek and prosecute the offender, the alleged perpetrator. And as part of that seeking, trying to track down the perpetrator, bearing in mind the police service was not as developed as it is today, these people, through the Association for the Prosecution of Felons, would hire individuals known as thief-takers. Thief-takers are effectively what you would now know as being private investigators. So there was no ANPR, there was no way of, with cameras, tracking movements of offenders in those days. So it was a much trickier affair to track down an alleged perpetrator or an offender. So thief-takers were the individuals that would go to the next town or go to the next village, and they would try and gather evidence to try and establish if they could track down through movements of the alleged perpetrator. So of course the only people that could really afford these activities or these organisations were those people who had wealth, who had high standing in society. And so criminal justice at that point was a very uneven system within society. There was no equality of access to criminal justice. Criminal justice, or getting justice through the criminal justice system, was the domain of those that had resources. Now, this separation between rich and poor at those early stages did lead to some problems of reprisals, you could say, because those that were in the working class or the underclass, as you may know now, who couldn't afford to take out any action against offenders, they were then the ones that were used to being either pigeonholed or labelled or tracked down as potential offenders. But yet they were never the ones on the other side that were having justice when they were victims. And so there was a bit of a suspicion from the lower classes against the upper classes, and this led to the problem of reprisals. So Emsley, writing in 1996, noted that the occasional attack on, or what was known as rough musicking of, a prosecutor is suggestive of communities which felt that certain offenders should not have been prosecuted or should have been proceeded against on a lesser charge. And so those in the lower classes felt they were being targeted often by those in the upper classes and being held down. So it may be that somebody from that lower class group did take part in some sort of criminal activity, let's say a very minor or petty theft. And they felt, the society around the accused often felt that when that accused was being taken to court, they were being treated exceptionally harshly, perhaps to be an example to others that might follow, but being punished disproportionate to the offence that had taken place. And this led often to reprisal attacks against the upper classes by the lower classes. And so there was, again, this increasing divide between rich and poor, a divide between who could receive justice, who couldn't, and then retribution, if you like, taking place both from the upper class against the lower class for criminality against them, but then also by the lower class against the upper class for what they felt was disproportionate targeting of those in their social groups. And so there was this complicated relationship that existed between class and justice and victimisation. And already at this point we begin to see really two aspects of victimisation. So as well as traditional victimisation, as you would know, being a victim of an assault, being a victim of a theft, we also begin to see emerging the notion of victimisation by the justice system itself, or victimisation by the state, or someone who is a victim because of the process they've had to go through. So you've got normal, if you like, victimisation on one hand, traditional victimisation, and structural victimisation on the other. And these two are both different things, but they're linked together through the criminal justice process to show that victimisation is somewhat multifaceted, if you like. Now, as the 19th century went on and then into the early to mid part of the 20th century, this central role of the victim in the justice system as being the one responsible for carrying out investigation and prosecution lessened and lessened and lessened. And it lessened because there was a much more modernised and developing police service as you would know it today that was now in place. And so no longer did ordinary people have to carry out investigations to the same extent as they used to do. Yes, you would still have things like private investigators, etc., but the majority of investigation by the time we get to the 20th century is being conducted by the police services as they exist today. So you've got the victim's role in the investigation of crime diminishing. We also, by this stage, by the time we get to the 20th century, have a much more developed prosecution system. We've got both the CPS down south, the Crown Prosecution Service down south in England and Wales, and we also have the Crown Office and Procurator Fiscal Service in Scotland, the COPFS. And so the prosecutions, as the state was now taking more interest, much beyond simply crimes against the state, but taking, by the time we get to the 20th century, a much greater interest in general criminality, general deviance in society, general issues of criminality between private individuals as well. And so prosecution of crime is now also taken out of the hands of the victim. And so gradually more and more what we're seeing is the traditional victim, if you like, that victim of the assault or the theft, etc., is at this point now their role being relegated simply really to that of a witness. The witness to have evidence gathered from through the justice process and to present that evidence in court. And so you've got the victim being relegated, if you like, from being extremely prominent to being almost peripheral to the justice process at that point. Now, at this point then, we begin to see, as we get from the mid to late mid, so between, let's say, the 50s, 60s, 70s, so the 1950s, 60s, 70s, we've seen reduction in crime initially through the early part of the 20th century as policing is developing. But we then see this sort of plateau effect whereby crimes stop reducing. And by the time we get to the 1970s, we've got crime really beginning to rise again. And we've got now criminology as a discipline by that point as well. So we've got scientific investigation into crime, into perpetrators of crime, the root causes of crime, etc. But yet crime rates are still rising. And so academics and practitioners at this point are beginning to panic a little bit, because in spite of research, in spite of development of the system, crime rates begin to rise and rise and rise. And it becomes clear that this rise in crime isn't just a one-off blip over a year or 2 years, but in actual fact we're beginning to see consistent rises in criminality at the time. Now we're going to return to this question later on then of what then happens from there. But what you do need to know before we get to the theoretical aspects of it later on is that what we begin to see at this point as the discipline of victimology is emerging, we begin to see a bit more prominence being given to the victim's role once again. Not going back to the point that victims are investigating and prosecuting crime, but developing the victim's role a little bit beyond simply being a witness, if you like. So we begin to see more focus on the victim. We begin to see more policies related to victimisation and victims emerging on a national basis and on a local basis as well. So we begin to see, for example, compensation measures. So when someone has been a victim of a serious crime, it is recognised, at least to some extent, that that is, yes, the majority of the blame lies with the offender, but that also to an extent it may be that an individual has been let down by a society that is supposed to try and protect its citizens. And so we begin to see things like compensation measures, the ability of someone that's been a victim of a serious crime being able to apply for and be given compensation for their victimisation. We begin to see, as we get to the late 70s and 80s, we begin to see the growth of victim support organisations as well. So we begin to see the Victim Support Scotland, we begin to see victim support in England and Wales. We begin to see other organisations that grow out of these organisations as well. Organisations like Women's Aid, like Rape Crisis, etc. begin to grow as the century continues. So we see victim support organisations, we see many more victims-focused policies, giving not quite legal rights at that stage, but giving some expectations and some policy that gives victims expectations when it comes to their interactions with the criminal justice system, safeguards for victims when they're being questioned by police, etc. So some examples of the legal protection that then does begin eventually to emerge for victims. We only really begin to see legal rights beyond policy considerations which could have been changed at any time. We only begin to see really legal rights being given to victims once we get into the 21st century, really. So starting in the very early 2000s, around about 2000, 2001, we see a couple of attempts at European Union directives which were trying to give a standard basic set of rights and expectations for victims of crime across all of the member states of the European Union. In other words, what the European Union were trying to do at this point, about 20 years or so ago, they were trying to ensure that if someone was a victim in the UK, they would have the same rights given to them as a victim of crime as if they were a victim in France or in Spain, etc. And there were some teething issues with the early attempts for the first 5 or 6 years that first EU directive on victims was in place. Mainly because the EU didn't have any enforcement mechanisms at that point, so there was very little they could do if an EU member state didn't comply with the directive. And so there was still some unevenness, if you like, or inequality or inequity in the experience of victims depending on which country of the European Union they were in spite of this EU directive being in place. This is until eventually about just shy of 10 years ago now, so just within the last decade, when the European Union went back to scratch and created a new EU directive for victims of crime. And what they demanded was that every EU member state had in place by 2015 its own domestic legislation that would give victims of crime in that member state in question specific legal rights and safeguards. Now, of course, as you know, until 2020 at least, the UK itself was a member state of the European Union. However, when it comes to criminal law and the criminal justice system, there are different systems in place in different nations of the UK. And so there couldn't be any one act, if you like, that would cover the entirety of the UK. So it was up to England and Wales on one hand, Northern Ireland as well, and Scotland to develop their own national legislation that would allow victims of crime to be given these legal safeguards within Scotland. And I'm happy to say that Scotland was in fact the first of the nations in the UK that enacted this legislation. And this was in advance of the deadline that EU member states were given. This was the Victims and Witnesses Scotland Act 2014. And so in this legislation, they went beyond simply giving victims legal rights and safeguards, but they also included witnesses within that as well. So victims and witnesses within this same piece of legislation, the Victims and Witnesses Scotland Act 2014, were given a number of legal rights and safeguards. And I can give you some examples of that. One example would be that if a victim has reported being victimised and there's an investigation into that victimisation, and let's say the accused is tracked down by the police and interviewed, but then the Crown Office and Procurator Fiscal Service, on looking at the case, looking at the evidence, make a decision not to prosecute. If they make that decision not to prosecute, if you were to go back to before 2014 and before the Victims and Witnesses Scotland Act 2014, there was nothing the victim could have done about that. There was no legal right given to a victim in that circumstance. If the COPFS decided the case wasn't proceeding, that was it. However, one of the rights given to victims under the Victims and Witnesses Scotland Act 2014 is that if a decision is taken by the COPFS not to prosecute, then the victim has the legal right to request a review of that decision. Now, they don't have the right to demand a prosecution takes place, but they do have the right to demand to be given a full explanation as to why the COPFS has made the decision not to prosecute. They do have the right to put forward an argument as to why they believe a prosecution should take place, and they have the right then for the seat to demand the COPFS looks again and reconsiders that decision on whether or not to prosecute. So that's just an example of one of the rights. There's other rights, of course, under that, and a full copy of the Victims and Witnesses Scotland Act 2014 will be placed on the MyUWS or Moodle site for Victimology. Please read that in full to understand the rights that have been now given as of only the last 5 years, because although it was 2014, it didn't actually come into place until 2015. So the legal rights that have been in place for only the last 5 years in Scotland. So it's a very recent piece of legislation. Now, we should be clear though that in spite of policies and laws that are in place, there still is very much more that could be done. There's still some distance to go before the lot, if you like, of victims could be deemed to be perfect, if there ever is such a scenario. And I personally don't believe that there ever is any possible system that can make everything perfect for victims of crime, partly by nature of what they've gone through in their victimisation, but also because regardless of whatever rights that are given to victims, we do have to remember there also have to be legal rights and safeguards given to those that are accused of committing crime. We can't simply take the word of victims and then prosecute and that's it. There are certain safeguards that have to take place in order to make sure that the person being prosecuted is indeed, let's say, the correct person, and that of course the accused person has the right to present defences and counter-narratives, etc. So there's always going to be a balancing act to be had between the victim and the accused, and we do need to be careful not to stray too far in one direction or the other. Of course, the reason these developments that took place in the mid to late part of the 20th century and then into the early part of the 21st century, the reason these developments took place is because it was felt that the balance had gone too far in favour of the offender or the accused, with very little by way of rights being given to the victim. And so some of the legislation and policy that has come into place in these last, particularly 20 to 30 or maybe even 40 years, a lot of the reason this has come in has been to try and redress that balance just a little bit further as far as possible. So, to conclude this part of the video, one final really important thing to examine that we've not really mentioned yet. What is victimology? We're talking about this term victimology. You're here to study victimology. But what is victimology? Well, what you have to bear in mind is you know what victims are, and it's the ology part. If you were to look at something like, let's say, biology, the ology part indicates this is a science. So victimology is effectively the science of studying victimization. Now, when we talk about science, we're not necessarily talking about, physical sciences or STEM. Now, that can be involved because, of course, if you're talking about forensic science, that is a part of victimology. But science simply means that we can have, let's say, a hypothesis. We can gather evidence. We can conduct research. We can make conclusions based upon research. There's a science involved in the process of studying victims. And so there's a number of different relationships that we could look at here in terms of scientific examination or scientific study or scientific research of victims. We've got the relationships that exist between victims and offenders. You will all know by now, at this point of your criminal justice studies, that in spite of sometimes the rhetoric that is presented about fearing the other or fearing the unknown, that in actual fact, the majority of crime that takes place worldwide, and certainly in the UK, actually exists between people that have got some prior knowledge of each other. Yes, there are predatory crimes. Yes, there are things like robberies whereby people don't know each other. But the majority of criminality, the majority of victimisation in the UK does take place between people that either know each other, maybe in a relationship, whether it's a relationship of family or marriage or friends, or people that know each other in some other way. There's a relationship that exists. In other words, there is some relationship between that victim and the offender. So victimology can be the scientific study of those relationships that exist and what within those relationships may lead on to some aspect of criminality or victimisation. We can also have the scientific study of the relationship between the victim and the criminal justice system. So earlier on in this victim, I talked about this second category of victimisation. So not traditional victimisation, but victimisation by the system or by the state. Systemic victimisation, institutional victimisation that can take place, whereby some of the criminal justice system or wider state systems may not be equal depending on, the big issue just now is related to race. Is there an institutional or systemic racism that means that people from a BAME background, a black and minority ethnic background, may be more likely to be targeted by the state and victimised by the state? So that's just one example, but there's the scientific study of relationships between victims and the criminal justice system. It may also be the relationship between traditional victims and the criminal justice system. So for example, victims of rape, how are they treated during police investigations? There's been a lot of focus on that over the last 20 to 30 years, and processes and practices have changed in line with a lot of the research that has taken place. That sort of research is victimological research. We can have a scientific study between victims and other social institutions. So yes, I mentioned, of course, the criminal justice system, but victimology does also look between purely criminal victimisation, and it looks into wider aspects of victimisation. So if we're talking about someone's social class, being born into a certain social class, and then someone being, let's say, unemployed, are they treated out? There's been a lot of discussion regarding the sorts of funding given by the state to unemployed individuals or state benefits, and the fact that we've had cases even recently in Scotland whereby there's been accusations that people have died as a result of having no state support. So there's a lot of different social institutions that we could look to there to examine the relationship between victims and those other wider social institutions, if you like. We also have scientific study of victimisation in the context of other victim-oriented issues. So we mentioned policies already. What about scientific study of victims' organisations, victim support services? What about the scientific study of activism, victims' activism? You'll have seen different victims groups that will come out and quite often lobby for more support or protest. The Black Lives Matter protest. If you were to study that, that is effectively a victimological study, because we're studying the issue of victimisation and a lobbying or activist group that is taking part in these protests and activism. So all of these sorts of things are victimology if you put in a scientific element. So if you're genuinely putting in place a methodology as part of that study, if you're conducting a literature review, if you are presenting something like hypothesis or aims and objectives, and if you're carrying out rigorous research into those areas, then that scientific research of victims in any capacity would be regarded as victimological in nature. So victimology is often quite critical of its forefather, if you like, its disciplinary forebear, criminology. So victimologists will quite often say that criminologists don't go far enough in their research because they don't take into account central issues of victimisation that also play into issues of offending and crime. And in the second video, we're going to come on and talk about that just a little bit more. But for now, thank you for watching, thank you for listening. Do bear in mind that this is of course a recorded video and there's some text on the screen that's going up throughout this video. Some of this might have appeared quite quickly and gone away, so remember you can go back and re-watch this, and you can pause the video at certain points or replay certain sections just to make sure that you've understood all of the things that we have been talking about. But for now, this is the end of part 1. I look forward to speaking with you again in part 2.